Yes, sir.
See, in personal guarantees, because under CRP there is a clear-cut process that you have to file a first you have to give a notice, and then under the notice, after the notice, if it is not responded, the debt is not paid, you can initiate a debtor creditor can initiate the process, CRP process under section 7 or 9. I'm not saying about 10. I'm not discussing that, but if there is a default, and this can happen. In case of personal guarantee, can a claim be based on an uninvoked guarantee? If guarantee is not invoked by a creditor. Now, there are normally what happens, there are a lot of creditors, particularly in case of personal guarantees, because it is linked to the corporate debtor. A lot of creditors are there, individual creditors are also there. Now, the guarantee in one case or two cases, because of one is lack of information, the knowledge with the lenders. Here we may also have some lenders attending this webinar. One is because of lack of knowledge. Second is because normally what happens, and normally large lending is done in consortium. Now in consortium there is only one agreement, and then there is one lead lender who is keeping all the records, or there is a security trustee where the trustee is having all the records, all the agreements, etc. And individual lenders may, because either lack of knowledge, or maybe because that they think because there is a trustee and we are in consortium, they are not invoking the guarantee, their respective guarantees against the respective personal guarantors. Can we accept, can a resolution professional accept a claim of uninvoked guarantee?
Sir, it is amply clarified in couple of judgments, especially Swiss Ribbons, sir, that it is that for the initiation of an insolvency resolution process against the personal guarantor, the creditor should invoke the guarantee by serving a demand notice. There are some particular forms which are given in the BG rules, but the invocation of guarantee is of utmost importance. So a claim has been clearly defined in Swiss Ribbons. I'll just read out the claim for you. Swiss Ribbons said the claim give rise to a debt only when it becomes due, and the claim is wider in definition than the debt. A claim may be due or may not be due, but a debt must be a claim which is due. The claims are filed by the applicants in various cases, but it was decided by the tribunal that the applicants cannot claim the amount in the CRP of the corporate debtor who is a corporate guarantor on the basis of a deed of guarantee, which was never invoked as on the date of filing of the claim. So it is clearly given in the Supreme Court judgment, which was Swiss Ribbons judgment, that the guarantee should be invoked. In one of the other judgments, which is Ghansham Mishra and Sons and Private Limited with the Edelweiss, it is also seen that the uninvoked guarantee cannot be considered as a matured claim. So that once the moratorium was applied under Section 14, a corporate guarantee cannot be invoked. So this is clearly at various instances and precedents, it is given that the guarantee has to be invoked. A notice has to be given, a proper procedure has to be followed, and we have to clearly demarcate that the claim has become due to you. The principle of corporate guarantee cannot be invoked once the CRP has commenced, and that uninvoked corporate guarantee as on date of filing of claim cannot be considered a mature claim, and that's why there is a utmost important that we should invoke the guarantee before the initiation of the CRP process.